Greetings, 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 greetings. As Isaiah your King, King Clifford Jefferson, I Senator Godfrey, the fifth Carolina Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know here at the Third Temple English Church of England as Jesus Christ. It is July 27th, 2024, which is the birth year equivalent 2974. I greet you in the name of my Queen, Sister Godwinson from the House of Godwinson. I greet you in the name of our officers, Archbishop Belmont from the House of Belmont, Bishop Search from the House of Searchy, as well as all other officers, members. I greet you in the name of the heirs, successors, our predecessors, our children, our mothers, our fathers, our uncles, our brothers, our sisters, all those who are trying to get an understanding of what it is that we are here in this present day, 2974, to know what it is that we were called to do. And that was to regain these lands. This reason why this lesson today is called America Will Pay. They're free and common Socage to the English here and heirs in the Anglo-Saxon, in the Anglosphere in the year 2024. Once again, America will pay their free and common Socage to the English heirs in this Anglosphere in this year, 2024. All right. This I will prove beyond a reasonable doubt. So all those who've been having ear to hear, listen what the voice of truth say to you. All right. So without further ado, I'm gonna get started with this marvelous lecture. All those who got questions, please post them in the chat, and hopefully I'll get to them as soon as possible. I won't hold you long, no longer than I should. All right. So once again, this lesson is called America Will Pay their free and common Socage to the English heirs here in the Anglosphere in this year, 2024. Okay? That is a promise. And today I'm going to show you step by step how this prophecy, promise was fulfilled. Okay? Pretty much of the material that we're going to go over, I talked about in prior lectures, prior podcasts. So none of the information is new. Like I said, I didn't come to change the law, but to fulfill the law. What law? The law that was passed by my ancestors, one being King Edgar the Peaceful, which I am the reincarnation of in this present day, by way of the incorporation of our religious society called the Third Temple English Church, with the corporation that was existed prior to our incorporation. So that means that under the law, under the statutes, all the laws that our religious society had back in what we call the time immemorial, we have those rights, privileges, honors in this day and time. So I will show and prove the record. You will not find this on any other podcast, and I will name them Brother Truth, Asher Ducateers, Canaanite Moors, Moorish Science Temple America, Sinetta Studios, Sarma Seti, House of Awakened Minds, the what they call the Know the Ledge. All you brothers and sisters are in a world of trouble as a result of you not knowing land rights, property rights. Once again, land rights and property rights. If you don't understand land rights and property rights relative to it having affiliation with you, then guess what? You're property. All right? Property cannot own property. All right? So I'm going to prove it again without a shadow of a doubt. Everybody, please pay attention. Hmm. Once, as you see here, you have a real estate book. Essentials on real estate. Thank you, Queen. Essentials on real estate. Everybody needs to get their state's real estate book. All right. Don't care what edition you get. You need to get your state's real estate book to understand what's being said to you today. All right. So this is right from the source. Okay. Indisputable. You tell one of the individuals or platforms that I just mentioned, Brother Truth, I share Duke of Tears, Kenny Knight Morris, House of Awakened Minds, Morris Sign, Temple of America, Sign Letter Studios, Sarman Susetti, Northern Ledge, Brother Reggie, Shamrock Susetti. You ask any one of them in their presentation in regards to any type of rights to inherit land, show them to tell them to show you some concrete proof. Okay, concrete proof validated by some laws that existed prior to you being born on this land, but yet within those laws, prior to you being born on your land, on being born on this land, had you in mind. Okay, those laws that preserve your interest in the estate was left not by a will, but some type of process where the land could be conveyed to you once you realized that you were the person that the land was supposed to be conveyed to. All right. It's very important for you to understand this because if you don't, then you have no estate at all. You have no estate at all. Essentials of New Jersey Real Estate, the 12th edition. Most of y'all are used to what you see here, lot and plot numbers. Okay, lot and plot numbers. Right? Lot and lot numbers. Plat sub Sea Pines Estate subdivision. Majority of them, when you have a deed and enter some type of property, is based upon a parcel estate. Okay, some tenure estate or some real estate. All right, as you can see here, recorded January the 14th, 1969. My birthday is January the 14th, 1970. Okay, that's my birthday, January the 14th, 1970. A year after the recording or whatever they're making reference to here in Lebert 275. Lebert means book, page 1346 in Atlantic County, New Jersey. Okay, very important. Let's see another diagram. Chapter 21, public titles and closing. Chain of title. The chain of title shows the record of ownership of the property over a period of time. An abstract of title is the condensed history of all instruments affecting a particular parcel of land. More science of America should be used to that term, parcel of land. All right. Through the chain of title, the ownership of the property can be traced from its origin to its present owner. Meaning there's no gap in the chain of title. All right. There's no cloudy title. You know the original owner and who conveyed the land to the grantee. Okay, the grantor and grantee. That as long as you have a grantor and a grantee, that makes a contract. Okay, especially when you're conveying or transferring property. If this could not be done, it said that there is a gap in the chain of title. A quick claim deed is commonly used to bridge such a gap. Okay, a quick claim deed bridges a gap. All right, it's something like what they call a lis pendens. All right, a lis pendens. Sometimes, however, it's necessary to establish ownership by a court action called a suit to quiet a title. Okay, it's called a suit to quiet a title. When dealing with owner of real estate, a purchaser or lender requires satisfactory proof that the seller is indeed the owner and has a good title to the property. If you got a gap in the title, then there's no good title. Okay, once I want you to all know that. Is there a gap in the chain of title, meaning that if you can't trace that title or that deed, which is a presumptive of a title, to the original grantor, then you don't know if it's good. It's not indefeasible. Okay? This documentary proof is called evidence of a title. So just because you have a deed in your possession does not mean that you have the right of ownership. Okay? It just means that something was lawfully conveyed to you as a grantee from a grantor, and that grantor can be a third party, i.e., an escrow holder, i.e., a stakeholder, i.e., what you call a real estate broker. Okay, since we still dealing with real estate broker, that in fact will be a real estate broker. All right. Evidence of the title. When dealing with an owner of real estate, a purchaser or lender requires satisfactory proof that the seller is the owner and has a good title to the property. This documentary proof is called evidence of a title. There are four generally forms of a title evidence. There's four. Listen very closely, everyone. First one, an abstract of title and attorney's opinion. First of all, that's the wrong type of evidence to present before a court of law, if you understand real estate law. An abstract title is not a concrete title. An abstract title is one that's not indefeasible because you can't trace it back to the original owner. Why? Because it ain't the owner who's selling the property to the grantee, it's the attorney who's doing the job. Okay? And usually that attorney is a licensed broker. All right? Two, title insurance policy. Title insurance policy is usually a clause in the actual contract that upon there being a lien put on the property after you buy it, that grantee has to have title insurance to pay them back for loss up to a certain amount or a certain percentage. Three, torrent certificates. Torrent certificates is another form of land purchaseship proving that you in fact are indeed the owner of property, and that's based upon four, the certificate of title. Okay? The certificate of title. All right. And in totality, a deed is not proof of a title. You hear that, y'all? A deed is not proof of a title. It proves the grantor transfers the property, but does not prove that the grantor had a good title in the first place. Does not prove that the grantor had a good title in the first place. The only effective proof must be one of the evidence of title based on the adequate search of the public record. Okay? Of the public record. Estates and interests in land. Estates and interests in land. This is the real estate book I'm referring to. All right. So when I go to Wikipedia, Wikipedia is going to validate what I'm showing you here in the real estate book, dealing with estates and land, which you call parcel and land, and we call it in our language land tenures. Okay, or feudal tenures, land tenures or feudal tenures. The land tenures or feudal tenures or the parcel estates or freehold estates, which we call them, are known in North America in three ways: fee simple, fee determinable, and life estates. There are the only three types of estates in North America, and they were derived by way of what we call common recovery. Okay, they was done by common recovery. This is how the land was stolen by involuntary alienation. You got voluntary alienation when you agreed to give up something, and you got involuntary alienation, which means that you didn't agree to take it over, so it was taken by another form, another fashion. This is what we call acquisition of sovereignty governed under the laws of discovery or the laws of conquest. Once again, acquisition of sovereignty under the laws of discovery or the laws of conquest, which is called prescription of sovereignty, which amounts to what we call easement by prescription, which is a non-possessory use in property that you don't own. And this usually originates from what we call estate. I mean, parts of interstate. Interstate is when a person dies with no heirs. Okay? Interstate is when heirs die and there's no one to transfer the land to. So it automatically transfers by way of a process called escheatment. Okay? A property called escheatment. Once the person dies or the parties died or the heirs died, then it automatically passes by escheatment. In this case, will be the state of New Jersey. The state of New Jersey takes the property under this what they call prescription of sovereignty or compulsory purchase, which is nothing more than what we call eminent domain. Eminent domain. So what they do is they take public land or what they call it's called public domain or federal lands, all right, which are actually called Commonwealth lands. They are actually belong to what they call the crown or part of what we call crown land under the king's radical title. So land needed for public use, when they take the land for public use, they must compensate you. But the persons who exceeded it, who went interstate, were never compensated because they assumed that these people were never around anymore. But it's mighty strange that we are around today because we are these English people who are the heirs, who the land was held in what we call intel estate, which is called crown land, contrast to the three you see listed in this real estate book called fee simple, life estates, and life what's it called life what's it called determinable fee determinable. Okay, fee determinable. All those have encumbrances. Okay, so once the land is taken for public use, it falls under the eminent domain power of that said state or that said county or that said municipality. All right, of that said state or that said county or that said municipality. Then it's taken or given to what they call the public government, the municipal government, all right, or your county government, and the land, the so-called property is auctioned off, okay, is auctioned off for public sale, all right, public sale, usually done at the county. This is called adverse possession, all right. Non-payment of a debt secured for real property results in foreclosures, which is sold to the highest bidder at a sheriff's sale. Once again, that's called adverse possession and adverse possessor. All right, it's very important that y'all understand these terms. We already went through them in prior lessons. I have to go through them again today. Right. So the only reason why any state has a right to the land and everything's on the land is a result of the eminent domain power. And the eminent domain power was only acquired because of an escheatment. And escheatment means that there's abandoned property somewhere, and nobody know who the owner is. So of course they it escheats to the so-called government. All right, and it's usually as a result of not making a will or no heirs, no descendants, etc. This is called involuntary alienation. Involuntary alienation. Okay? When you alienate the land, this is called subinfeudation. Okay? Subinfeudation. All right, we can do this. Queen, warm this up. This is not working. Show me any one of the groups, platforms have taken a position to bring such a claim before any court of law. We've done it. This is being done in this present day. Okay? This is being done in the present day. State of New Jersey versus King Clifford Jefferson. All right? The state of New Jersey versus King Clifford Jefferson. This matter is being heard right now within the county government in New Jersey, in New Brunswick Superior Court, 96 Patterson Street. Okay? 96 Patterson Street. All right? The complaint numbers here. I was arrested February 21st, 2024. All right? They're past the indictment stage. All right? They're past that now. So that means that this is a malicious prosecution. And as a result of that, I can file a claim against the state of New Jersey. All right? As a result of the malicious prosecution. All right? Which will be heard at a probable cause hearing that's yet to be scheduled. All right? So it says here, it's on this day, April 17, 2024, that King Clifford Jefferson petitioned this court by way of this prerogative writ for the party in the matter above. The state of New Jersey has taken a position as a stakeholder, broker, escrow agent, and shareholder by interpleading for an unknown owner in the matter concerning property that has rightfully escheated to the Crown. All right? So the state of New Jersey has brought a claim against I, your king, as a result of their assuming that I lawfully created a deed and try to present that deed to a county court in lieu of claiming or try to transfer the property to myself or the Third Committee of the Church of England or the Crown. All right? So they're saying this was a lawful act. This is what they're saying. It was an unlawful act to do so, which is, according to them, is a second-degree felony. All right? A second-degree felony. All right? Now, the state filed the lawsuit against I, your king. All right? But the state don't own the property. The state is only acting as a stakeholder as a result of their interest they have in the property because they allowed the broker to be able to sell the property to an individual such as you and I. Okay? But it wasn't us who bought the property. It's usually somebody else who has an interest in the property. And they don't even have a lawful possession of the property because the deed that they had is not proof of a good and valid title as stated in the real estate book. Okay? So what the state has done has took the position as an interpleader. An interpleader is a civil procedure device that allows a plaintiff or a defendant to initiate a lawsuit in order to compel two or more other parties to litigate a dispute. A interpleader action originates when the plaintiff holds property on behalf of another but does not know whom the property should be transferred to. This is such a case. The state of New Jersey has filed a lawsuit and allowed two individuals to interplead on behalf of property that the state don't know who actually owns it. I'm telling them I own it, but the state saying I don't, and there is their burden to prove. All right. It often used to resolve disputes arising under insurance contracts. And in interpleader action, the party initiates the litigation, normally the plaintiff, who is termed the stakeholder. Right? United States Supreme Court, Liberty Oil versus Company versus Condo National Bank, a case in 1922, concurs where an action of law and thus converted into an interpleader, it is to be treated thenceforth by a trial in the appellate court as proceeding in equity. The issue between the claimants need not, under the Seventh Amendment, which is right to trial under the common law, be submitted to a jury, but may be tried by a court and the judgment be viewable in equity and not as at law. Okay, so this matter must go before a court of equity, which is usually a court of chancery. All right, which I have the obligation to do as I interplead for the king, since I'm acting as the king of England in lieu of that station because it's called the crown. The crown is represented by the monarch, known as what we call a corporation sole. We are a corporation sole. Let's move forward. United States Supreme Court Fountain versus Ravenel, 1854. The executives were vested with a mere power of appointment. You hear that? So anybody talking about they have the right to execute a trust on your behalf, they're lying because there's only a mere power of appointment without having any special trust attached to it. So you don't have no authority to execute a trust if you were not appointed by the grantor or the creator of the trust. All right. And the trust that we're talking about is land. And you can't have any physical property or what we call what's the word they call it? Uh personal property or movable property without having somewhere to put that personal property or that movable property. And usually that involves some type of surface, some type of land. Okay? You ain't carrying around with you. All right. You ain't on the water, I suppose. So the executors were vested with a mere power of appointment. You must be appointed by the one who created the trust in regards to the land. This all involves the land. All right. In England, the case could only be reached by the prerogative power of the crown, acting through the sign manual. Acting through the sign manual of the king. The English American cases upon this subject examined. Mr. Justice McLean delivered the opinion of the court. The bequest under consideration was intended to be a charity, the donor having entire confidence in his executors substituted their judgment for his own. They are the survivors of them was to designate such objects of his charity into two states as would be more beneficial to mankind. It was to be placed on the broadest foundation of human sympathy, not excluding the color of race. It is not charity to give to a friend. It's not charity to give to a friend. In the book, it is said that Thanksgiving becomes a charity where the uncertainty of the recipient begins. This is called abandoned property, bona vacatia. This is beautifully illustrated in the Jewish law, which requires a sheaf to be left in the field for the needy and passing stranger. It may be admitted that this bequest would be executed in England. A charity rarely, if ever, fails in that country. The only question there is whether it should be administered by the chancellor, i.e., a court of chancery, i.e., a court of equity, because he represents the king's consciousness, or in the exercise of the ordinary jurisdiction, or under the sign manual of the crown. Did everyone hear that? Under the sign manual of the crown. So what is the sign manual? Let's read it. It's still dealing with that case. It says here, where there is no trustee, the king, by his lord chancellor, administers the trust as the keeper of the king's consciousness. I just said that. And it's not important whether the chancellor acts as the special delegate of the crown or the king acts under the sign manual. His discretion being guided by the chancellor, it may be well again to state the precise question before us, as well as this court of law, where this matter is being heard. All right. So we see it right there in this case law in regards to the authority that the Court of Chancery have or the authority that the king has under his royal sign manual, which means his signature. The royal sign manual is the signature of the sovereign by the fiction which the monarch expresses their pleasure either by order, commission, or warrant. A signed manual warrant may be either an executive act by the example, an appointment to an office, you hear that? Or the authority for affixing the great seal of the pertinent rim. Remember, people change, positions don't. People change, positions don't. We're talking about any position. You get fired, what happened? They put somebody else there. Evidence. Escrow agent licensed by the state of New Jersey and a list of depository escrow accounts because uh, uh, um, every broker, i.e., every escrow agent, every licensed attorney, which could um, uh, realtors or i.e. brokers are licensed attorneys. Okay, you must understand that, and they are responsible for keeping what they call an escrow account. All right, and it says here, based upon the statutory law and revised statute 45:15-12.5 2023, it says every individual, partnership, or corporation licensed as a real estate broker should maintain in a state or federally chartered bank, savings and loan association, or other depository institution physically located and authorized to transact business in the state and approved by the commission, a special account into which the broker shall deposit and maintain all monies received while acting in the capacity of a real estate broker or a escrow agent, or as the testamentary custodian of funds of others in real estate transactions in the state. So all those who claim to have opening up trust, knowing trust law and transfer estates or creating a state, then where's the escrow account? Where is the escrow account that you must have? Everybody's just paying these people amounts of money to make a trust account for them, and they don't see no escrow account. All right, very important. The account should be maintained in the name in which the individual, partnership, or corporation is licensed to do business as a broker and should be designated as either the broker's trust account or escrow account and should be maintained separate and apart from all other personal and business accounts. Did y'all hear that? Is Brother Truth dropping it like that? No. Is Sister Tears dropping it like that? No. Is the Kenite Moores dropping it like that? No. Is the Morris Science Temple America dropping it like that? No. Sinetta TV Studios? No. Sarma Susetti? No. How to Awaken the Minds? No. Is Brother Reggie? No. Is the Know the Ledge? No. Who's doing it? The Third Temple English Church of England. And this is being done in a court of law in 2024 and a court of criminal court for them claiming that I'm actually doing something lawful when actually everything I was doing something unlawful and actually I was doing something lawful. Okay, because de facto means uh the what is it? De facto means the what is it? The what is this? Sovereignty. You got two types of sovereignty: de facto and de jure. De jure means the legal right to do so, and de facto means the basic uh what is it? The legal right to do so, de jure, and the de facto is the basic fact to do so. Okay, so based upon their facts that they present to do so, don't mean it's legally and lawful. All right, because when it's dealing lawfully, it must be substantiated by the law. New Jersey Administrative Code 11:5-1.1. This is New Jersey. The Real Estate Commission is responsible for the supervision and regulation of the education, examination, and licensing of the real estate broker, broker salesperson, and referral agents. The regulation of the sales or lease, lease of out-of-state properties to New Jersey residents through promotional activity in New Jersey. All this is regulated under administrative code. Do y'all see this? All right. Do y'all see this? So the license to steal your property has been regulated by the state by way of their eminent domain power as a result of escheatment because they claim that you don't exist no more. So the land became interstate, meaning that there are no more heirs. All right. I don't know how many times I gotta go over this with y'all, but if you don't listen, when this movement or this intellectual movement comes to fruition, like it is now, it's just a matter of time. Like I said, this lecture clearly states that America will pay their free and common soakers to the English heirs in the Anglosphere in this year, 2024. I mean this. All right. United States Supreme Court, Chisholm versus Georgia. Jurisdiction of the court. Indeed, I take it to be generally true that in all cases where the subject is the nature of the plaintiff to recover anything from the king, his only remedy at common law is to sue by petition to the person of the king. You hear that? To the person of the king. I say, when the subject comes as a plaintiff, we're talking about somebody interpleading for property that they don't know who's the actual owner of. So if somebody don't know who the actual owner from the Kingdom of England, there's only right that I, King Clifford Jefferson, interplead for the king, because in order for somebody to take the property, he must be sitting in that position as king. And I did that by way of what we call incorporating. So I'm able to interplead for the King of England since I'm standing in the position as the King of England. How I know it? Let's see what it just said. I repeat, indeed, I take it to be generally true that in all cases where the subject is in the nature of a plaintiff, to recover anything from the king, his only remedy at common law is to sue by petition to the person of the king. All right, the personas of the king, the ideals of the king. I say where the subject comes as a plaintiff, or as I said before, when upon a title found for the king by office, the subject comes in to reverse the king's title or to show his own right, he comes in the nature of a defendant and is admitted to interplead in the case with the king in defense of his title, which would otherwise be defeated by finding of that office. So if no one's sitting in the office, then that individual could not interplead as the king because it will be interrectum. There is no interrectum because now somebody's sitting in a position as the king, and now I have the right to interplead for the king by way of one of title of office. All right, which will be defeated for the finding of that office. All right, we must understand what's being said. The same case. This is the only law concerning corporations to which I can see the leave reference is to be had in the common law of England on that subject. I need not repeat the observation I made in respect to the operation of the law in this country. We talk about this America. The word corporation, in the largest sense, has a more extensive meaning than people generally are aware of. Okay? So you don't understand what the word corporation means? The true meaning of the word corporation, the different types of corporation, you better listen now. The word corporation, in the larger sense, has a more extensive meaning than people generally are aware of. Anybody politics. Once again, we talk about a government, y'all. A body politics is a government. This word gonna come up again in a second. Any body politics means a government, whether it's de facto or de jure. It represents a government. They said sole or aggregate. Our religious government is called a corporation sole. Your government under the Commonwealth or Republic is an aggregate. All right, it's separation of church and state. Under the fusion of government, there is no separation of church and state. So that means that the king and government, the executive branch, parliament, and the judiciary branch, the king's bench, are all fused together as one. It's called what, y'all? The crown. I need not repeat the observation I made in respect to the observation of the laws in this country. The word corporation in the larger sense has a more extensive meaning than the people generally are aware of. Any body politic, sole or aggregate, whether its power be restricted or transited, is in the sense a corporation. The king, accordingly, in England is called a corporation. It's just called the corporation sole, not a corporation aggregate. So also by a very respectful author, Shepard, in his abridgment, Volume 1, page 431, is the Parliament itself, and Parliament is an aggregate. It is this extensive sense not only each state singly, but even the United States may, without impropriety, be termed corporations. Y'all better listen. I have therefore, in distinction to this large and indefinite term, used the term subordinate corporation. So the states in the United States, which are aggregate, are subordinate corporation because the only one that can create a corporation is the king. All right. I'm not going to say that. They're going to say it in this case law. I have therefore, in contradistinction to large and indefinite term, used the term subordinate corporation, meaning to refer to such only as a loan capable of the slightest application for the purpose of the objection, whose creation and whose power are limited by what, y'all? By law. The difference between such corporations and the several states in the Union, as relative to the general government, are very obvious in this following particular. First, listen, y'all. A corporation is a mere creature of the king or of parliament, very rarely of the latter, most usually of the former only. Did you hear that? Of the former only. Tell any one of those podcasts to show you this. A sheep power of the king. State versus Otis Elevator Company, Superior Court of New Jersey, March 3rd, 1952. Indeed, it would seem especially inappropriate to require a claimant to establish his claim by clear and convincing proof in cases such as this where the state is seeking to take unto itself by exceeding property belonging to private persons. You hear that? Exceed and forfeitures are not favored by the law, and any doubt should be resolved against the state. Admittedly, the substituted receiver claim must rest upon the strength of their own title, but he should be required to establish his claim only by a preponderance of the evidence and not by clear, convincing proof. All right, y'all better listen to what I'm telling you. Ma versus State, Superior Court of New Jersey, Chancery Division, 1951. New Jersey had no General Estate Act until 1946. Did you hear that? Now, we just read that based upon the example I showed you in New Jersey real estate book, that the only way New Jersey got the land was by a street. And the only way it is streeted is because of interstate, meaning that they said what no people here and who had the land originally. And we know these people are who? The English. The English. I'm going to prove it to you. All right? We're going to have a good, it might be a long night tonight, y'all. It might be a long night tonight because I'm going to leave no stone unturned and nobody's going to have any remedy for not obeying what's presented for you on the record. It says Mall versus State, a 1951 case. Specifically, let me read the start from the start. New Jersey had no General Estate Act until 1946. When adopted, it contained no express repealer of revised statute 3:59-1011. However, the state says that since the legislation of 1946 was dealing with the precise subject covered by revised statute 3:5-9 in sequence, an implied repeal follows. Cedar Grove, on the other hand, argues that the statutes are not repugnant; they are in pari materia, and effect should be given to both. Specifically, its position is that since the Estate Act speaks generally of a person who dies intestate with no heirs or known kindred capable of inheriting, while the Distribution Act deals particularly with cases of intestacy where the personal property is found in the hands of an administrator, the particular legislator, i.e. the Distribution Act, to be regarded as the exception. The general legislation, i.e. the Estate Act. So the suggestion is that the Estate Act applies to all personal properties of the descendant who dies intestate, except where the property is found to be in the hands of the duly appointed administrator. In the case, the Distribution Act controls the municipality's takes. Okay, so you must understand in regards to the Estate Act where the origin of the Estate Act descended down from, and we know that belongs to the crown. How I know it? Let's read it. Supreme Court of New Jersey, State versus Otis Elevator Company, 1953, case law. I'm just going to the highlighted part. Actually, I think I'll start from the top. I got time. In modern usage, it signified. Now, remind you, y'all, we're reading from Supreme Court of New Jersey. Okay? Supreme Court of New Jersey, we're reading it from to validate our position in regards to this criminal complaint that the state of New Jersey got against King Clifford Jefferson and the Third Temple English Church of England, which are incorporated as the corporation, so which they call the Crown of England. Okay, we're the Crown of England. We are the government. King calls Parliament. Okay, Supreme Court of New Jersey State versus Otis Elevator Company 12 New Jersey.1. Okay, this is a matter already rendered by the highest court in New Jersey. And modern use, it signifies the falling of property to the sovereign for one of the owner. You heard that? To the sovereign. Okay? When there's a sovereign, there's no other equal. And this category embraces not only property which has no other owner, but also property whose owner or whose owner's whereabouts is unknown. Okay? Under the common law of England. Why is Supreme Court of New Jersey talking about the common law of England and talking about its streets under the common law of England? Because it says right here, and I repeat, under the common law of England, a street came to be classified as what, y'all? Another branch of the king's ordinary revenue. We call that free and common socage, which we're going to talk about in a second. Blackstone commentary states what was originally an incident of tenure, i.e. fiddle tenure, i.e. parcel estates, which you call here real estates. What was originally an incident of tenure is now an incident of sovereignty. All right? The doctrine of a sheet at the earliest common law operative only upon that which was the subject of any type of tenure, since it related to the reversionary right or remandment right of the lord to take for want of a tenant, was eventually extended to include personal property, tangible and intangible. You hear that? Personal property, tangible, intangible. We're talking about slaves, y'all. We're talking about Negro, black, colored, Ethiopians, Mexicans, all of them were considered property because you're property of the state of New Jersey. You are property of the state of New Jersey. Why? Do what we call involuntary alienation. They alienated you from your nation. They alienated it from your country. They alienated from your culture. They alienated you from your laws. They alienated you from your protection. Is any of this making sense to any of y'all? The doctrine of his cheat at the earliest common law operative only upon that which was subject of tenure, since it related to the reversionary right of the lord to take for one of an owner, was eventually extended to include personal property, tangible and intangible. The principle was that the right to take that which belonged to no one appertained to the crown as part of the crown's, i.e., the monarch's jural regalia. Anybody ever heard of that word? Brother Truth, have you ever heard of that word? Alshir Dukatir, have you ever heard of that word? Kenite Moore, Science of America, Sign Never TV, Sign Rasoon Seti, House of Awakened Minds. Of all platforms, have you ever heard of that word? Jural regalia? No. Why? Because you don't know nothing about the crown. You don't know nothing about the king. You don't know nothing about England. And if you don't, then guess what? You have no inherited estate. The crown steps in to take property because it is vacant. Property described as bond or vacantainer is taken or assumed by the estate by way of what we call escheatment. All right. Then they're taking it by eminent domain power, which is called compulsory purchase or acquisition of sovereignty. Okay. That's how they take it. It's not lawful, but if you don't know who you are and don't know what rights protect who you are and what belongs to you, then guess what? They're going to take it involuntarily. Property of this class falls to the crown as a matter of right in the exercise of its sovereign power. In personal estates, I'm talking about all your states right now. Every black person, every nigger, every colored, every individual over here in North America, even if you're not nigger or color, all your person, the federal government don't own a Lolio. The highest form of ownership is fee simple. And fee simple is not it's a gap in the chain of title. Why? Because it all belongs to the crown. And if they trace it back to the crown, that means that they will all be in serious trouble. They will be in serious trouble. It just said the crown steps in to take the property because it is vacant. Property described as bona benedictina is taken or assumed by the state. We know what assume mean, right? As its own, as its own. That's what they've been doing. Property of the class falls to the crown as a matter of right, not under the assumption, but as a matter of right in the exercise of its sovereign power. In personal estates, which are allodial by law, the king is last heir where there is no kin. So how you claim you can have allodial land on any type of estate and land when you're not an heir to the king? Because the king is last to take the land that's allodial when there is no heir to take on and hold on to that what they call personal estates. You own nothing, y'all. You own nothing. It all belongs to the crown. There's one more before I move forward. Okay. The king is last where there is no kin. Now, let me show you where New Jersey is a bunch of trouble. They're in a bunch of trouble because they're suing me. All right. The King of England, King Clifford Jefferson. They're suing me. We have the certificate of incorporation. We have the charter under 46 colon 3 dash part so 46 colon 3. What is it? Get it right. 46 colon 3. All right. Jersey about 46. 46 colon 3 7 dash point 9. I think I got that right. I'm gonna show you anyhow, so it don't make a difference. I'm gonna show you that we, the Third Typical English Church of England, are in fact a government. A government. The rulemaking power of the Supreme Court is not subject to overriding legislation. They said that in Billen versus Harris, which we're going to review again today. It is confined to practice, procedures, and administration. Must give way when the state is a party to an action. You hear that? When the state is a party in action, the state is a party in this action. In such cases, it is maintained that the legislator may prescribe the procedure and that such legislatively prescribed procedures may be in conflict with the rules of the court related to practice, procedures, and administrations and will override the rules of the administrative court. Y'all better listen to me because this is what's taking place right now. We can find no basis in law or equity for such a bill, but on the contrary, we cannot but regard such a suggestion as fraught with great inconveniences because it will lead to two systems of procedures, one for the ordinary litigation and the other for litigation involving the state. Indeed, in this bill, the legislature might prescribe as many different systems of procedures as there are or might be proceedings to which the state is a party, thus defeating the objective of uniformity, simplicity, and flexibility that are the goal of how new procedural systems and that it is conceded throughout the country have been in large measure achieved here. If this doctrine urged on us were accepted, it might even be extended to all criminal trials because the state is necessarily a party. You hear that? This is a criminal proceeding. This is a criminal proceeding. It said if the doctrine urged us were accepted, it might even be extended to all criminal trials because the state is necessary a party. Let's see how much trouble they in, which is last highlighted part. But it's far more important the procedural difficulties of a viable or even a multiple system of practice and procedure is the grave substantive danger of conceding to the state a preferred position in the court as a plaintiff. You hear that? Who is the plaintiff in this case right here in criminal court, in superior court? It's the state of New Jersey. And it's just right here. The state of New Jersey will be a dangerous move to come into court as a plaintiff in regards to the power you claim to have as a streetman. We just read that anything in the street automatically reverts to the crown because it's a allodial. It cannot be separated from the crown because all land is allodial. It means there are no encumbrances, y'all. There are no encumbrances. It said, but far more important than the procedural difficulties of rivals or even multiple systems of practice and procedures is the grave substantive danger of conceding to the state a preferred position in the courts as a plaintiff. one of the signal triumphs of the common law as distinguished from the continental system of jurisprudence is that for centuries it has been a recognized principle that everyone is subject to the rule of law, and that no man is above or beyond the law, says Braxton. The greatest of the early writers of English common law, Rex non debet et sed sub homine sed sub due et sub lege quae facit regime. The king should not be under any man, but under God and under the law, because the law makes the king. Y'all hear that? The law makes the king. All this is being argued right now in New Jersey Superior Court of New Jersey. There's the complaint, there's the docket number, there's the parties, and here's the king. Okay? So you can go right now and look it up, and you can see it's a valid complaint. And they are past their deadline in regards to establishing an indictment, and which calls for a probable cause hearing in lieu of their non-indictment. Okay, which automatically going to result in a malicious prosecution. Okay, a malicious prosecution. How many of those platforms are out there putting in work like this? How many are out there putting in work like this? We got this document I wrote up myself, but let me show you the evidence based upon evidentiary fact as well as evidentiary law. I'm going to show you in law and in fact, okay, that what you just read here is indeed true. All right, let's get it. The Jersey Provincial Council was the upper house of the New Jersey legislature under colonial rule until it was replaced by the New Jersey Legislative Council under the New Jersey Constitution of 1776. As we look in the box on the right-hand side, political group, local fascists, list of term, indefinite, which means it's forever. Authority, the crown. Territories under the itinerant government was what? Perth Amboy and Burlington. We're in Perth Amboy now. Okay, so we are up and operating. Okay, we're up and operating like the government like the government was when it was established here in New Jersey. It says the provincial council was established in 1702 upon the surrender by the properties of East Jersey and those West Jerseys of the right of government to Queen Anne. Anne's government united the two colonies as the province of New Jersey, a royal colony establishing a new system of government. The instructions from Queen Anne to Viscount Cornbury, the first royal governor of New Jersey, it didn't say president, it said governor of New Jersey, outlined a fusion of power system which allowed for an overlap of the executive, legislative, and judicial authority. It provided for a bicameral legislative consisting of a council and general assembly. This was supposed to be forever, indefinite under the crown. What happened? They overthrew it. They overthrew it to this present day. But look what they did when they overthrew it, because they left crumbs. Let's show them the crumbs they left. Origination of the common law. You go right here on New Jersey courts, the same court where this lawsuit is pending, where this article is presented as evidence about who we are at the Third Tip English Church of England and the Anglo-Saxon Berbers, who are the ones who had this government reestablished through our certificate of incorporation. On the 46:1-46, let me just make sure. I hate giving the wrong statute. 46:7-9, I think that's it. 46-7 dash 7. New Jersey revised statute 46-7 dash, what is it? Come on now. I'm overlooking it. 16:1 43.9. 16:1 dash 43.9. Right there. We're going to go through it right now. And that statute right there is going to show you, in fact, that we are indeed, in fact, a government. Okay? We are, in fact, indeed a government under the statute. All right? We're not going to go there yet. All right? I want to draw my conclusion. I want to draw my premises. Just like we did when we talked about mathematics. This is our mathematical proof based upon our proposition, which is based upon our premises, which we draw our conclusions on. All right? To get out the matrix. This is how we get out the matrix that they built. All right. So New Jersey Provincial Council, we proved that New Jersey Provincial Council in 1776 was under the authority of the Crown, and it was indefinite. So when the government was created under Queen Anne government, the laws governing that government was indefinite. So how did it become indefinite to definite? I mean, how did it become indefinite to now temporary? All right, how did it become a temporary government now? They overthrew it. Why? How did they overthrew it? By separating church and state. Okay, they moved from a corporation sole to a corporation aggregate. With Chisholm versus Georgia said the only person that could do that was the king. All right, was the king through his signed manual when he signed those charters. Just like the charters George Carteret and John Berkeley have, what they said, they were surrendered back to what? The crown. So they were surrendered back to the crown in 1702. And we know that in 1776 Constitution, it said there was supposed to be a reconciliation with the crown. All right? There's supposed to be a reconciliation with the crown. That has been, in fact, done. We have done that. All right, let's see. Property rights and land. John Wallace, Maryland University. Couple of questions we all should ask ourselves. Hell, if they're doing it in the university, you should be doing it at home. Right? Y'all on TV talking about property rights, heirs, and all that. Well, you need to ask yourself the same question that were posed by John Wallace, who wrote this thesis in University of Maryland. Property rights and lands. Questions. How did the American colonies establish property rights in the land to begin with? All right. What did the revolution do to exist in property rights? Okay. How did Americans allocate property rights to land outside of the original colonies? What are property rights? These are the questions that each and every one of y'all should be asking yourself, especially if you are of English ancestry. When I say that, I mean Anglo-Saxon Berber. All right, very important. The first settlers of Jamestown in 1607, when you're talking about Jamestown, you're talking about the Scottish monarchs. All right, Queen Anne, Charles II, Charles I, James II, James I. I mean James the Sixth of Scotland, the first of England. We're talking about all the Scottish monarchs going all the way back to the Treaty of Union in 1707. 1707. And they was over here in 1607. All right, they was here in 1607. They didn't become a union in 1707. Prior to that, England, Ireland, and Scotland parliaments were separate. And the parliament that's running over here was not Scotland, it was not Ireland. It was England in 1702, prior to their unification. So it says the first settlers of Jamestown in 1607 were adventurous lot lots motivated by hopes of finding gold, silver, and the water passes to the east in the hope of acquiring land. The operation was a risky one, made more risky by the continuous warfare between European powers and the hegemony of Spain, particularly the Spanish Navy. The colonists wanted protection from the king, in return for which they were quite willing to offer a king's share of profit for their ventures. The Virginia Company charter issued in 1606 by King James created the Virginia Company and granted the company rights to settle land in the king's name, either appertaining unto us or which are not now actually possessed by the Christian prince or people, situated, lying, and being all along the seacoast between 4 and 30 degrees of northerly latitude from the equinoctial line and 5 and 40 degrees of the same latitude, and in the mainland between the same 4 and 40 degrees, and the islands thereunto adjacent, and within 100 miles of the coast thereof. The king was to provide the colonists protection, in return for which he was to receive a share of any gold or silver found by the colonists and a share of the land sales of the colonists. So I mean, they were over here mining for gold and silver on behalf of the Scottish monarchs, all right, as well as the Spanish monarchs, as well as the Frankish monarchs. All right, we have to understand this history. Two very important parts of the charter follow. First, everyone who lied in the colony will be subjects of the English king. Did you hear that? Everyone will be subject to the English king. That was part of the charter. Part of the charter. So if your deed don't recognize that, then there's a gap in the chain of title. Also, we do for us, our heirs and successors declare by this present that all and every that persons being our subjects, which shall dwell and inhabit within every or any of the said several colonies and plantations, and every of their children which shall happen to be born within any limit and precinct of the said colonies and plantations, shall have and enjoy all liberties, franchise, and amenities within any of our dominions, to all intents and purposes, as if they had been abiding and born within this our rim of England or of any of our said dominions. So the same laws applied here is the same laws in England. And all lands sold by the Virginia Company will be held in free and common socage. Did y'all hear that? It will be held in free and common socage. How many of you know what free and common socage are? How many of you know what that means? All right, because the land was held for a specific people. When it was rented out under subsidization by common recovery, i.e. fee simple, that means that they were just raising money. It was just raising revenue. That's called feudal tenure in states. That's why you pay taxes. That's exactly why you pay taxes. Guess who set that up? William the Conqueror. He set that up. And it's been existing to this present day. Guess when it ended, y'all? It ended in 1664. It ended in 1664. Wasn't no feudal tenures anymore, but there was free and common socage here in North America, i.e. New Jersey. All right? I'm proving it. I'm showing you the proof. Socage. Socage was one of the feudal duties in land tenure formed in the English feudal system. We know who was the first English renowned king? William the Conqueror. Prior to that, the only kings ruling in England was Anglo-Saxon Berbers. Free and common socage was a form of duties called feudal duties under the English feudal system. It eventually evolved into freehold tingers called free and common soakers. So freeholders, now called your county commissioners, were the ones who were paying soakage to the king. Guess what? They stopped, and they got you paying it. All right, they got you paying it now. Farmers held land in exchange for clearly defined fixed payments made at specified intervals to feudal lords. In turn, the lord was obligated to provide certain services, such as protection to the farmers and other duties to the crown. Payments usually took the form of cash, but occasionally could be made with goods. Ain't you paying cash now? Aren't y'all paying cash now? Come on, y'all. Think. Socage contrasts with other forms of tenure included sergeantry, Franklin Moyne, and knight services. The English statute Queen Imperatrix of Edward I, 1290, established that Socage tenures which passed from one generation or nominee to the next will be subject to inquisition post-mortem. Inquisition post-mortem, which would usually involve a feudal relief tax. This contrasts with the treatment of leases, which could be lifelong or readily subject to forfeiture and rent increases. Okay? Very important. It said it should be subject to inquisition post-mortem. That falls under what we call library of season. Let's go to library of season. We talked about this already. Those who don't remember, you need to go back and watch the videos. Library of season is an archaic legal conveyancing ceremony formerly practiced in feudal England and other countries following English common law, used to convey holdings and property. The term library is closely related to, if not synonymous with, delivery used in some jurisdictions and contract law or related laws of deeds. The oldest form of common law provided that a valid conveyances of feudal tenure and land require physical transfer by the transferors to the transferee and the presence of a witness, of a piece of ground itself, in a literal sense, of a hand-to-hand passing of the amount of a soil and a twig or a key to a building on the land or other token. You do it now by way of a key to a building. Okay, same principle. Key to a building. So we know that it said that the Socage was subject to inquisition post-mortem. Inquisition post-mortem dealing with library of season. Under feudal systems, all land belonged to the monarch. Did y'all hear that? All land belonged to the monarch, as and was therefore either held by him directly, the royal damsel, or on his behalf directly or indirectly. Those who held land directly on the king's behalf were known as tenants in chief. When a tenant in chief died without any heir, his lands ceded to fell into the hands of who? Not the government, not the state. It says right here, it fell into the hands of the king. Just like they said in Chisholm, what was it? What was that case law? If I'm not mistaken, Chisholm versus Georgia. All right, they said it right there in that case. It fell into the hands of the king. If there was an heir, the king kept the land until library of season took place, and the heir paid a sum of money, a relief to take lawfully assume possession of the land. So any type of conveyance of land, whether it's a library of deed or library of law, it must be made by way of the king. Okay? It must be made by way of the king. Because there are two ways to convey it. Library of season and library of law. All right? Very important. The politics of New Jersey. So we know, based upon how America attained property, they said it was under free and common Socage. I know Socage goes back to Edward the First under what we call Inquisition post-mortem, where it said that the king held on to the property. That means if the king held on to the property, that means that the crown holds the property. All right? The American Revolution in 1776, the first Constitution of Jersey was drafted, written during the American Revolution. All right? We talk about New Jersey's Constitution. We know in 1702, New Jersey was under the crown. We know in the Constitution of 1776, it says that the colony is supposed to reconcile with the crown, okay, of Great Britain. We know Great Britain had three crowns: Ireland, Scotland, and England. Well, it was under Ireland and Scotland when they broke away. All right, so the only one they can reconcile with is England, because under England they had a de jure government. So we see here in 1776, the first Constitution of Jersey was drafted, written during the American Revolution. It created a basic framework for a state government and allowed all the inhabitants of the colony of full age who are worthy of £50 proclamation money to vote, including black spinsters and widows. Married women could not own property under the common law. The Constitution declared, I repeat, itself a temporary and void if there was a reconciliation with Great Britain. Guess what, y'all? There is a reconciliation with Great Britain. How we know it? Let's prove it. All the other platforms that's out there incorporated got platforms on YouTube, TikTok, Facebook, because you see them all on there. Brother Truth, Sincere Ducateers, Canaanite Moors, Science of America, Sign Letter Studios, Samatu City, House of Working the Mind. All of them assume to have some type of incorporation, okay? As they call themselves a social society. If you call yourself a social society, you should have some type of certificate of incorporation. We call them charters. All right? We call it a charter. First of all, let's go to this is in fact my certificate of incorporation. They go to county, New Jersey, recorded, religious society, a corporation, so 161-28. All right? I've showed you this plenty of times, but y'all think this is a joke. You really think this is a joke? Okay, all right, the joke gonna be on y'all. Name of this religious corporation should be the Third Temple English Church of England, only for heirs and successors. The physical address of the religious corporation is in the care of 360 Lehigh Avenue, Perth Amboy, New Jersey, province of New Jersey, which we know was a crown, called provincial council under the kingdom or within the kingdom of England. Type of business type, corporation sole, a royal peculiar. We know versus Chilling versus George is only two. Corporation sole and aggregate. You see here, we're corporation sole. Okay? A corporation sole is a legal entity consisting of a single sole incorporated office occupied by a single sole natural person. This structure allows corporations, often religious corporations or commonwealth governments, to pass without interruption from one office holder to the next, giving positions legal continuity with subsequent office holders having identical powers and possessions to their predecessors. Did you hear that? Do you see that? The power that I have, the power that we have as a society. Yes, we are a society. We are a society. What is the business purpose of our religious society? The means for our ordinary transfer of ecclesiastical property serving to keep the title within the denomination or religious society in order to keep the religious property from being treated as it is in this day as an estate to the vicar of the church or the Roman Catholic Church. The property was titled to the office of the corporation sole. A corporation sole is the crown, is the legal embodiment of the executive, legislative, and judicial governance and the monarchy of each Commonwealth rims. Did you see that, y'all? This is what the state of New Jersey has to deal with. Okay? This is what they have to deal with in that criminal proceeding. These monarchies are united by the personal union of their monarch. but they are in independent states. The concept of the crown developed first in England as the separation of the literal crown and property of the kingdom from the person and personal property of the monarch. Okay? Article 5, duration, perpetual. Just like it was in 1702, it was indefinite, it's perpetual now. Okay? It should show you, in fact, we are indeed a government. 161-43.9. These are the powers. Powers or consolidated corporations. The consolidated corporation shall have and may exercise all powers conferred by the respective certificate of incorporation or charters of the constituent corporation, and by Title 16, in particular, the powers conferred by Article 5 of Chapter 1 of Title 16, not Title 14, but Title 16 of the revised statute, so far as the same are not inconsistent with this act and are necessary or convenient to the furtherance of its objects and are in accordance with the doctrine, government, discipline, and uses of the church or religious denomination to the jurisdiction on which the constituent corporations were subject. It shall have, among other powers, the powers to invest, change the investment of, and reinvest its endowment, the funds of such investments, whether or not prescribed by statute in such manners as it should deem proper. Did y'all hear that? Did y'all see that? All right, let's see. We talked about sign manual. Last page of our charter. 61-28, right seated under the charge of Great Britain, saved from repeal. An act to incorporate trustees of religious society and incorporates in place thereof. Once again, 61-28, right seated under the charge of Great Britain, saved from repeal. Act to incorporate trustees from religious societies for property held in corporations in place thereof. It said in Chisholm versus Georgia, who created the corporations? The king. All right. So if corporations owning property that belongs to Great Britain, who is the individual who can get the property? Only the king. You see here, you got the signature. Who? Clifford Jefferson L. in my private capacity, but in my office, king as corporation. So, okay, there are our church wardens. They are our church wardens. All right, there is our seal. Articles of Incorporation 1 through 12. It was witnessed. It was witnessed by who? Notary acknowledgement. The statute of frauds by Charles II was created in April 16th, 1966, which said all contracts in regards to property, I mean any contract for that matter, should be in writing. This contract is in writing, ain't it? All right? To avoid fraud on the original creditor. On 4/16/2022, before me appeared Clifford Jefferson, Dion Belmont, our Archbishop, and Lisa Jordan, our treasurer, personally known to me or proved to me on the basis of satisfactory evidence to be the persons whose name is or subscribed to the within instrument, and acknowledged to me that he or she they executed the same in his or her their authorized capacities, and that by his or her their signature on the instrument, the persons or the entity upon behalf of which person acted executed the instrument. Witnessed by hand and official seal. Signature of Notary Taylor Jones from the state of Ohio. Do y'all see that? Now, why is this important? Let's go to the authority of what we call recording. Who has the authority to validate a recording in the county clerk? Reports and recommendations relating to recording of title documents. Did you hear that? Of title documents. This is New Jersey Law Revised Commission. New Jersey Law Revision Commission. They revised the statute. All right. Now look at what they say. Based upon who has authority to validate a title or deed. Section 4. Officers authorized to take acknowledgement of any title filed within the county clerk. The officers of this state authorized to take acknowledgement or proof in the state or any other United States or foreign jurisdictions are what? 1, an attorney at law. 2, a notary public. 3, a county clerk or deputy county clerk. 4, a register of deed or mortgage or deputy register. 5, a surrogate or deputy surrogate. If you use 1, 3, 4, or 5, you're screwed. If you use 1, 3, 4, 5, you use those methods, you're screwed. And if you use number 2 methods and you're not a king of England or heir to England, you're screwed. You're screwed. You are screwed. Why? Let's see. Let's go to property. New Jersey Law Revision Commission. This is something, this ain't new. I already showed this already. State of New Jersey Law Revision Commission. All right. This is the Law Review Commission. Property. They try to revive our ancient laws. Our brothers and sisters. Let's see. Let's see. These very statutes, 46.3-1, 46.3-4, all these statutes right here remains the laws governing our estate here in North America. All right? A common law rule regarding the acquisition, vested, or disposition of an estate or interest in real property that is not codified or specifically modified or superseded by this act should not be construed to have been modified or repealed. Listen what they say. This section contains streamlined and consolidated language from the source section as follows. A is taken from New Jersey Revised Statute 46:3-1. B, and it's taken from 46:3-5. 46:3-5 deals with Queen Imperatrix. And we know free and common Socage passed by Edward I was under Queen Imperatrix. All right? And this very statute, New Jersey, deals with that. Let's see. It says here, the phrase fee simple has been used to indicate ordinary title to real estate. It has been substituted for free and common Socage, a phrase used in some of the source statutes. That is a violation of law. Free simple is not the same as free and common Socage. Free and common Socage was supposed to go directly to the king as a tax for fee simple, so fee simple could not be free and common Socage. Also, the phrase has a number of meanings, but in this context, it is identical to fee simple. You hear that? Fee simple is also intended as equivalent to elogio, a word used to some of the older cases as meaning a form of ownership not subject to any rent, service, or acknowledgement to any superior. So how in the hell could fee simple be equivalent to elogio if it's subject to some type of rent, service? Because fee simple is subject to some type of rent or services, i.e. taxes. So why is they lying to not just you, but to the government. They're lying. Fee simple and allodial are not synonymous. Fee simple and free and common Socage are not synonyms. All right? You must understand. Let's see. It just said right here. Free simple is equivalent to allodial. But let's see. Allodial. Let's see if it's the same. Who you gonna believe, them or me? They ain't gonna tell you the truth. Allodial title. That was the question you asked, Brother Noonley from the House of Noonley. Well, so Queen, did you get peanut butter? Allodial title. Allodial title constitutes ownership of real property. All right. Allodial title constitutes ownership of real property, land, building, and fixtures. That is independent of any superior landlord. Allodial title is related to the concept of land held in allodium or land ownership by occupancy and defense of the land. I don't understand your question, Brother Nolan. You said you for sure. Once again, the allodial title constitutes ownership of real property. You ask, you ask, who you ask, who will I believe? Oh yeah, that's right. Yeah, okay, all right. All right, that's what's up. Thanks. All right. Allodial title constitutes ownership of real property, land, building, and fixtures that is independent of any superior landlord. So how in the hell could fee simple be equivalent to allodial? That's what they just said, right? Let's go right to it. Fee simple is also intended as equivalent to allodial. This was New Jersey Real Estate, New Jersey Law Revision Commission said that fee simple was synonymous or equivalent to allodial. That's what they said right there. Fee simple is also intended as equivalent to allodial. All right, so that's what New Jersey Law Revision Commission said. But we're reading the definition of allodial now. And it said allodial title, right? Allodial title ownership, allodial title constitutes ownership of real property, land, building, and fixtures that is independent of any superior landlord. Allodial title is related to the concept of land held in allodium, or land ownership by occupancy in defense of the land. Most property, listen, y'all, ownership in common law jurisdiction is fee simple. In the United States, the land is subject to eminent domain by federal, state, and local government, and is subject to the imposition of taxes by the state and local government. And there is thus no true allodial land. Land is held of the crown in the England and Wales and jurisdictions in the Commonwealth rim. Did y'all hear that? Did you hear that, Brother Newley? So that means New Jersey Law Review Commission is lying. They're lying. Fee simple and allodial is not the same. And the United States, the federal government, the state government don't own the land allodial because they own it fee simple because it's subject to what they call the eminent domain power of the state, the eminent domain power of the federal government. All right. So once again, who are you going to believe? Brother Noli said he's going to believe the king. That's your best bet, Noble. That's your best bet. All right. So we see fee simple is not the same as allodial. Because he just said, United States is subject to eminent domain by the federal and state and local governments, subject to the imposition of taxes, i.e., free and common socage. All right. And therefore, there is no true allodial. They're talking about the United States, and New Jersey is in or one of the United States, isn't it? New Jersey is one of the United States. All right. We know Jersey was the crown. We showed you New Jersey represents the crown. Let me just show you again. New Jersey, the crown authority, indefinite. There's a fusion of government, the executive, legislative branch, and the judicial branch. R1. Why? Because they represent the crown. If they represent the crown, that means the crown, the land is allodial. How we know that? Let's go to the very statutory law to prove that the land is allodial. All those who want to ignore what I'm saying, it's not going to look good for you. It's not going to look good for you at all. I mean this. So you don't have to subscribe. You don't have to uh, talk on the chat line. You can stay silent like you've been. I could care less. I can care less. The job gonna get done with you or without you. Gifts, grants, conveyances by the state of New Jersey, Olodio. Now we just read New Jersey law revision said that fee simple was equivalent to Elodio. But we don't see this in the New Jersey revised statute, the statute governing property. Title 46 says right there, property. So let's see what it says. See if it's equivalent to fee simple. All gifts, grants, or conveyances made prior to and after July 4th, 1776. 1776, that's 1776, of any estate of inheritance by a letter patent under the Great Seal of the State of New Jersey or any other manner by the State of New Jersey, by its legislature thereof, or by the commissioners known as freeholders, or their agents, or forfeited estates, or by other lawful and competent authority under the state, shall be and remain allodial. Did it say fee simple? No, it said allodial, and not feudal, and shall forever be and continue in free and pure allodium only, forever discharge of feudal tenures and the interest thereof, and all other services whatsoever. That's the New Jersey Revised Statute. Let's go to my certificate of incorporation and see if that's validated. Right there. You see it right there. Gifts, grants, conveyances by the state of Lodial. All gifts, grants, and conveyances made prior to after July 4th, 1776. The year they declared their independence, this land has always been allodial. Not fee simple, allodial. So if New Jersey files a complaint against me, right? If New Jersey files a complaint against King Clifford Jefferson, let's go to it. What do I do with it? All right. Here goes the complaint number. Right. If New Jersey filed a complaint against me, there go the docket number, complaint number, prosecutor against me for a property, one single blot and lot number, a property, right? And they're trying to prove that that property don't belong to the crown. Hell, I just proved the whole state of New Jersey belongs to the crown based off the statute. Okay, so by you bringing a claim against me, as a result of you claiming I don't own this single property, now you're going to mess around and forfeit of giving up the whole state of New Jersey because actuality, the whole state belongs to the crown. The whole state belongs to the crown. You just read it. Title 46, colon 3-6, the whole land of the state of New Jersey of any inheritance, gift, grant, conveyance, etc. It is allodial. Do you agree with me, Brother Nonally? Do you agree? Let's see. Thank you, brother. New Jersey Revised Statute. Certain tenures and holdings turn to free and common socage. We're talking about free and common socage. Free and common socage, as we said, started with Queen and Taurus. If Queen of Pretoria, the English statue Queen of Pretoria of Edward I, the son of Henry III, the son of Henry II, the son of Godfrey V, Count of Anjou, the son of Fulk V, ruler of Jerusalem, he passed this statute called Queen Imperator of Edward I. All right? that said that free summer cultures would pass from one generation until this present day. All right, and will be subject to Inquisition post-mortem. And we know that was based upon it being, if there's no heir, it was street to the king. All right, it was street to the king. So we'll see Queen Imperator Edward the First pass dealing with free and common soakers. We're gonna go right back here to revised statute. Certain tenures and holdings turn to free and common soakers. It's still right here in the present day, all the way back from 1290 to 2024. We see the same statute dealing with free and common soakers. All right. No tenures, though. No filial tenures, because all filial tenures have been abolished. That required free and common soakers, but because there ain't no heirs, it is ceded back to the king. How we know it? It says it right here. The tenures of honors, manors, lands, tenements, or hereditaments of estates of inheritance at the common law held either of the King of England, that's called Inquisition post-mortem, held either by the King of England or any other person or body of politics or corporate at any time before July 4th, 1776, declared by Section 3 to be in free and common soakage forever. All right, so if that's the case, let's go to 4.6-1. Filial tenures abolished. Filial tenures abolished. The filial tenures of states and the incidents thereof taken away, discharged, and abolished from after March 12th, 1664. March 12th, 1664 is when Duke of York gave the charter to Charles II. I mean, Charles II gave a charter to Duke of York, who gave charters to George Carteret and John Berkeley, which were the ones who governed in the state of New Jersey. It was called Jersey before it became New Jersey. And we know that the charters that they had given to him by Duke of York from Charles II were surrendered back to the crown in 1702. And from 1702 to 1776, there was a fusion of government until it was overthrown by the administrative government called New Jersey. Okay? We must understand that. What we see here, based upon Title 46, 3-6, it says the land is allodial now. We see here, ain't no filial tenures anymore. It says it's been abolished. Filial tenures, estates, and the instance thereof, taken away, discharged, abolished from March 12th, 1664. The day Duke of York got the charter from Charles II, it says that shall continue to be taken away, discharged, and abolished, and no such state or instance thereof shall in any time be created in any manner whatsoever. So all the filial tenures created from the time of William the Conqueror in 1066 are gone. Are gone. William the Conqueror started the filial tenures. All right? It's very important that you understand that. All right? We know that free and common soakage, as they said, was regulated by the statute of King Imperator to Edward I, established the soakage tenure, which passed from one generation or nominee to the next and will be subject to the Inquisition post-mortem, which would usually involve a filial tax, which you call free and common soakage. So we'll see Queen Imperator passed by Edward I and the statute. Let's go to it. Let's see your other platforms present this type of information. They cannot do it. Queen Imperator. How did this statue get in here to the New Jersey statue from England? How could King Edward I statue, who was the King of England, who was a descendant of the Plantagenet crown, how did his statue get in New Jersey? How? Someone please explain that to me. It says it right there. Queen Imperatoris Terranum. All right? Terrarum means the land. Queen Pitoris, alienation of freehold. All right? It's right there. So for all those who don't know what Queen Pitoris is, let's see what it says. This is what it says, Brother Nunoli. Queen Pitoris is a statute passed by the Parliament of England in 1290 during the reign of Edward I that prevented tenants from alienating their lands to others by substitution, instead requiring them, all tenants who wish to alienate their land, to do so by substitution. You hear that? Now we know Edward I was the one who did what? Who expelled Scotland from England. Guess what? We're going to expel them again. And all those who were allowed to come over here as a result of what Scotland did by way of taking the power and authority that was under the crown of England, and they took it under the interregnum by transferring them to what they call now in this day a republic form of government. This government belongs to us. All right. Queen Pitoris is a statute passed by the Parliament of England, and damn it, was right here in New Jersey. What's here? Alienation of freehold. Statute Queen Pitoris. From from and after March 18, 1795, any freeholder or commissioner may give or sell or alien the real estate whereof he is, or at any time shall be seized in fee simple, or any part thereof, at his pleasure, and such only purchaser or alienee shall hold the same free of tenure or service to the donor, seller, or aliener. That's a criminal act right here. That is a straight up criminal act right there. You was not supposed to alienate the land, but you did it anyhow. You did it anyhow. Right? You did it. The proof is right there. How they do it? Common recovery. Common recovery was a legal proceeding to transfer fee simple estates and to intel estates and to fee simple. Let's just see. Common recovery. Common recovery was a legal proceeding in England that enabled lawyers to convert a intel estate, a former land ownership called fee-tail, into absolute ownership fee simple. Isn't that what New Jersey just did? Isn't that what the United States just did? Because they said the higher form of ownership in the United States and any state is fee simple. Therefore, there is no allodial land. We know that under New Jersey Revised Statute 46:3-6, it says the land is allodial. Not just that land, New Jersey, but every land, because when New Jersey gets there, everybody else go first. Everybody else follow. New Jersey was the crown, and all the charges given by the crown were those original 13 colonies. Okay, and every other incorporated state are subject to the laws that were governing the colonies, because states are nothing more than what? Colonies. All right, let's get there, y'all. This is dropping it. Let's hear it for yourself. English seized overseas possessions. The English seized overseas possessions comprised varieties of overseas territory that were colonized, conquered, or otherwise acquired by the Kingdom of England before 1707. You hear that? Before 1707. So all this over here, lit up in red, was the Kingdom of England. Did you hear that? Was the Kingdom of England, and all that Kingdom of England goes all the way back to look at the colonies. All of them right there. All of them right there. And from 1707 on back, All those territories here in the Anglo sphere, including the colonies you see here, were under the Kingdom of England going back where? To 927. Under who? Asterton. And Asterton was a melanated brother. Okay? Asterton. From during 927, during the rule of the House of Ninglinga, that's the Danish kings, from 1013 to 1014 to 1016 to 1042, England was a part of a personal union that included domains of Scandinavia. In 1066, William the Conqueror, Duke of Normandy, conquered England, making the Duchess a crown land of the English throne. What is crown land? Crown land, sometimes called crown land, also known as royal domain, is a territorial area belonging to the monarch, who personifies the crown. You hear that word personified? We call it incorporate, you call it incarnate. It's equivalent to of an intellestate and passes with the monarchy, being inseparable from it. Today, the Commonwealth Rim Crown Land is considered public land and is apart from the monarch's private estate. Let's go here. Parsons versus New Jersey. New Jersey Supreme Court. State of New Jersey by Theodore D. Parson, Attorney General, plaintiff, respondent versus Standard Oil Company, defendant, appellant. Supreme Court of New Jersey, 1950 case. This is Rockefellers, y'all. They're talking about the Rockefellers. Right here. We're talking about his street. There is no substance to the contention that under the Constitution of 1947 Constitution of New Jersey, the Street Act limits the operation of the statute of limitation, even to the point of the divesting and accrual right of defense under its provisions. The argument is that these statutes having lost all force and vitality upon the abrogation of the Constitution of 1844 by the adoption of the Constitution of 1947, again came into full force and effect simultaneously by virtue of their wholesale reenactment under paragraph 3 of the new Constitution. And so they must be read together and reconciled. And therefore, the Street Act is not subject in any manner to the statute of limitation, but the mere continuance of these statutes by constitutional fiats is not indicative of the purpose to abrogate vested rights to defenses permissible under the statutes of limitation. There is no suggestion of legislative design by the original enactment to annul the bar of the statute of limitation and revive in favor of the state a debt or demand that inter parties had lost its vitality by the operation of that statute, i.e., the statute of limitation. The Constitution of 1947 does not give the statute a radically different quality and meaning. Y'all better listen. In modern usage, its street signifies the falling of property to the sovereign for want of an owner. And this category embraces not only property which has no other owner, but also property whose owner or whose owner whereabout is unknown. Under the common law of England, estates came to be classified as another branch of the king's ordinary revenue. I showed you that in my case law that I used in the criminal case. Blackstone's commentary says the doctrine of estate at the early related to the reversionary right of the lord to take for one every tenant was eventually extended to include personal property, tangible and intangible. The principle was the right to take which belonged to no one appertaining to the crown, as jure regalia. Crown steps in to take the property because it is vacant. Property described as bona vacatina is taken or assumed by the state as its own. Property of this class falls to the crown as a matter of right and the exercise of the sovereign power. And personal estates, which are allodial by law, the king is last in heir where there is no kin. I don't know how many times I have to repeat this to y'all. Okay? It's very, very important. In closing, Bellin versus Harrison. The state of New Jersey, whose boundaries coincide with the district of one of the original 13 states of the Union and a common law state, The structure of its law may be looked to the further general background about the prerogative writ in general, which is a writ of circulator, or what we call a petition of right, or petition for certification. New Jersey's first constitution, adopted July 2nd, 1776, terminated its status as the English colony unlawfully and began its sovereign existence as a state. Article 22 of the Constitution continued the common law of England in force. The Constitution was replaced by the Constitution of 1844, modeled largely in structure and content on the Constitution of the United States. By Article 10, Paragraph 1, it too continued to enforce the common law as well as the existing courts of law and equity. So also the current Constitution of 1947 by Article 11, Section 1, Paragraph 3, continuing to enforce all existing law. It was long ago settled that the former Supreme Court, as established by the Constitution of 1844, was vested with all the powers of the King's Bench, which was the legislature with powers to cut down or to assign to other courts. This principle was especially strong in the field of prerogative writs, in which the circulator was one of the frequently sought. The complexities and technicalities of these prerogative writs including circulator, induced the draftsmen of the 1947 Constitution to erase these procedural necessities by preserving the judicial authority and their remedies, which was not allowed. Because when you did that, you violated the very law that was governed under what we call the Provincial Council, which says the crown was indefinite. And you stated in your New Jersey political body of politics, you said that there was supposed to be a reconciliation with Great Britain. Let's read it before I close. 1776 Constitution of New Jersey, going all the way back to the Revolution, it clearly says right here, the Constitution itself was temporary and void if there was a reconciliation with Great Britain. Did you hear that? With Great Britain. Once again, the reconciliation has been done by way of our charter or our certificate of incorporation, going back to 16:1 that's 7.9. And let's read it in closing. So let me just read this. 16.1-4, our authority. The Third to English Church of England under New Jersey by Statute 61-4 says, the powers of every religious society or congregation incorporated by the virtue of any law of the state to have the power to what? A, have perpetual succession at such corporation. B, sue and be sued. Plead and being pleaded in any court. C, adopt and use a common seal and author and renew the same at its pleasure. D, appoint such officers, agents, and employees as may be required for its properties, institutions, and businesses. E, make bylaws and rules consistent with the laws for the regulation and management of its affairs, properties, and institutions. F, acquire, purchase, receive, have, and hold, and take by device, bequest all gifts without limit, real or personal property of all kinds, churches, edifices, schoolhouses, colleges, college buildings, parsonage, sister houses, hospital, orphan asylum, and all other kinds of religious, ecclesiastical, education, and travel institutions in the land. Did y'all hear me? In the land whereupon the same are may be erected, and the cemeteries or burial places, and any real estate suitable for any and all of said purposes. G, lease, grant, sell, or dispose of all or any part of such property. H, borrow money for the purpose of the corporation to give bonds, mortgages, therefore, or any part of its property. Have the managed directors of control of all civil and temporal affairs of the congregation, church, or parish. And J, exercise any corporate powers necessary and proper for the carrying out of the above enumerated powers and the purpose of the corporation and its institutions. Did you hear that? So these are our reserved powers, okay, that were incorporated in our certificate of corporation, pursuant to 16.1-28, saving the rights under charges granted by Great Britain, being Section 12 of the Act entitled an Act to incorporate the trustees of religious societies, approved April 9, 1895. What was it? 875. Saved from repeal. So this statute was saved from repeal, and this act was an act. This section vested property held under charges of incorporation granted by Great Britain and corporation created in place thereof. So going back to my affidavit that I brought before the criminal court, it says it right here. Who creates the corporations? Chisholm versus Georgia. Indeed, I take it to be generally true that in all cases where the subject is the nature of the plaintiff to recover anything from the king, his only remedy at common law is to sue by petition to the person of the king. I say where the subject comes as a plaintiff, for as I said before, when upon a title found for the king by office, the subject comes and traverses the king's title, or to show his own right, he comes in the nature of a defendant and is admitted to interplead in the case with the king and defense of his title, which otherwise would be defeated by a finding of the office. What office? The office of a corporation sold. The only law concerning corporations to which I conceive the least reference is to be had in the common law of England on that subject. I need not repeat the observations I made in respect to the operation of that law in this country. The word corporation in the larger sense had a more extensive meaning than you really generally are aware of. Any body politic, solo aggregate, whether in the power be restricted or transcended, in the sense is a corporation. The king accordingly in England is called a corporation. So also by the very respectable author, it's parliament itself. And the extensive sense, not only each state singly, but even the United States may be within propriety be termed a corporation. Had therefore, in contradistinction to the large and indefinite term, used the term subordinate corporation, meaning to refer to such only as capable to slightest application for the purpose of that objection, whose creation, whose powers are limited by the law. The difference between such corporations in the several states in the Union as well as to the general government are very obvious in the following particulars. One, a corporation is a mere creature of the king or parliament, very rarely of the latter, mostly usually of the former only. So in closing, our document clearly says that I am, in fact, according to the proof authorization signed by the Notary Public of Ohio, it clearly says that I am, in fact, a king. Let me show you the document. Witnessed by the Teller Jones, the Notary Public, and signed by its officers. Right there. So any one of y'all a part of these movements, better tell them to show you something like this. All right? You better show you something like this because we are, in fact, and indeed, a government. So with that, I'm make sure I showed you everything. Yes. So with that, me incarnating as King Edgar the Peaceful to restore the Benedictine reform that he established in 927 is what you have here at the Third Temple English Church of England. So please come home, record your name in the book of life so you can have an estate as an heir and successor of the illustrious estate that were left by your ancestors on all the way back to time immemorial. And with that, we here at the Third Temple English Church of England is going to greet you as we meet you, and that's always in peace.